topic today are tips to operate compliantly and stay off the radar. This is a different type of webinar than what I normally give, which is on usually a specific change in the law that I'm going to address. Today I want to cover some things that are going on in healthcare that are impacting everyone, whether they know it or not, because the vast expanse of oversight is continuing to grow. We thought that there was nothing else that could possibly be investigated, and we're finding recently that there's new ways and new targets, and I want to make sure that everyone understands what that means to them, and some very simple things you can put into your practice in the day-to-day that will help you stay off the radar and operate compliantly. For those of you who do not know me, my name is Jennifer Kirschenbaum. I'm the managing partner of our healthcare department at Kirschenbaum & Kirschenbaum. And we do a lot of education. If you're not on our listserv, feel free to email me after the fact, but I think most of our participants are, and are regular participants on our listserv. So today, I want to talk about general areas of exposure. And when I made this list, it was really just off the top of my head, the areas that can create most exposure for you in your practices on the day-to-day. And in your practices, I'm also kind of including vendors here. Any billing companies we may have on the line, or labs or anything else, we're going to cover things that are relevant to you as well. So obviously patients walking in the door, the ones that we're treating on a day-to-day, they're coming in with a whole host of rights that come along with them, and then also issues that they may have with treatment and things like that. Payors we're going to go over. This is including Medicare and any third-party payers we're dealing with. No Fault and workers' comp have their own issues that we're not going to get into as much today. But certainly if you have any questions on those other areas, you can give me a call anytime. Third parties such as labs, pharmacies, other vendors, relationships with billing companies, consultants, testing companies, things like that, they all fall in here. And then, of course, last but not least, our employees who help us run our practices on the day-to-day. There's a huge area of exposure here, from wrongful termination to claims of inappropriate workplace and things like that, to payment issues, and we'll touch upon that very briefly. The format that we're going to go over today is just general areas of exposure, recent investigations, and items that have come up actually just in the past 2 months. Everything we're going over today has been reported on by the Office of Inspector General within the last 2-month period, which is crazy because you'll see how many different things we're going to touch upon. I'm going to try to keep today's webinar under an hour. I'm not sure exactly how long it's going to run, but I'm going to try for between 40 minutes to an hour. I know everyone has other things to do with their day, so we'll see how quickly we can get through the material. Patients and exposure. The big one that most of us are worried about is malpractice. I'm not going to cover malpractice extensively. I'm just going to make some general comments, and then we'll move on. Malpractice is what you have insurance for. I know that we have some of our colleagues, some of our physician colleagues that may be running without insurance or have a lag period. Please don't do this. We do step in and handle defense in such instances, and I can tell you that it's not pleasant. I hate getting those phone calls that I had a claims-made policy and I didn't properly activate the tail. I didn't have coverage, and I had a patient come in. I saw them anyway, and now I have a claim. I didn't think this could happen. What am I going to do now? Well, that's really where you have the most exposure. If by any chance, and it's not standard for this to happen, it doesn't happen often. I would say, it's a 1 in 1,000 chance that I've seen this come up, where there is a lag time in coverage, and then you are looking at expense from a malpractice claim, and I would ask that you avoid that under any circumstance possible. If you do have insurance, it's very rare. It does happen sometimes where a policy limit will be exceeded, and in that instance, certainly it's important to have done planning and moving certain items out of your name, but really most doctors go through their career, and even if they are sued 1 or 3 times throughout, which is the average, they likely will not be seeing a lawsuit or an injury that would exceed a policy limit, so that's less of a concern. That's all I'm going to say about malpractice right now. We could have a whole other talk on it. I will say this, though, for a tip, which is what I'm giving you. If you're having a bad day or you understand things didn't necessarily go the way that you want, always apologize and do it appropriately. If you think that you may have done something wrong and a patient is inquiring for records, notify your attorney, notify your malpractice carrier immediately. If you're not sure what to do, you can always call me, and I will be happy to give you advice. Licensure is an area of patient exposure. Patients can complain to OPMC or OPD, which is the New York government agency overseeing licensure. Each state has a different area of their Department of Health that oversees licensure. So if you're in New Jersey or Connecticut or New Mexico and you're listening, there is a Department of Health subdivision that handles licensure, and patients can report. So can anyone. Anyone can make a complaint. And that's significant exposure, suspension, revocation. They can order you to work under supervision. They can order you into treatment programs, things like that. It's significant exposure. You've worked very, very hard to get your license. That's how you're earning your living, most likely, for most of us on the call. And anytime you have licensure exposure, you have to be very, very careful. Never, ever, 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 ever speak to a government investigator personally. Always make sure you've engaged counsel, if for no other reason than to have a gatekeeper of information and a way to vet the message that you want to give. They will use anything you say against you, similar to your Miranda rights warnings. They are there for a reason. The Miranda rights, they will be used against you, whatever you say, so please do not speak to investigators. That's one of the biggest mistakes I think that doctors make. They assume that they're educated professionals, they're competent, and they're capable of communicating clearly. That may be true, but please do not speak to any government investigator, period, whether it's from OPMC, whether it's from the Department of Justice, U.S. Attorney's Office, DA, DEA, anyone. Do not speak to a government investigator under any circumstances. HIPAA exposure, we're going to get into this. There is significant exposure with HIPAA now because there are civil monetary penalties that can come in. We're going to talk about very basic tips that you can put in place at your practice to make sure you're protecting against HIPAA exposure, and that's going to be a good portion of today. Prescribing. For any of us who are doing prescribing of any controlled substances, there's new requirements in this state, in New York, and other states that we check and make sure we know the prescribing history of patients. And we'll touch on that briefly because there's also significant exposure there that you can very easily protect against. So we're going to get to some examples on what's going on right now. Oh, before I do that, sorry, here's our slide on prescribing. If anyone wants a copy of this, you can let me know. But if you're doing any Schedule 2, 3, or 4 controlled substances, you must register and check the prescription monitoring program. This is new for New York as of August. And if you don't have your sign-in information yet for your Commerce account, please make sure you get that immediately. This is a very, very hot area, and the regulators and authorities are looking to investigate and to make sure that there's no crazy pain med prescriptions going around. We're going to get to that and their oversight actions that they've taken recently, which are significant. So if you want this information, just feel free to email me. Most of you have my email, but it'll be up later on in the presentation, and I'm happy to spend more time. We also have on our website, which I'll give you a couple of times, one link to the website is practicewebinars.com. I have other webinars that are already posted on the prescription monitoring program. One of them is only 7 minutes long. It's a very quick overview on responsibilities and how you can access and when you don't have to check the registry. If you are checking the registry, make sure that you indicate in your notes that you've done so. If you're not checking, the government knows you're not checking because they can check registry information at any time that they want. The Department of Health is overseeing this. Okay, we're going to get to some of our examples and why I was compelled to put together this presentation for you today to give you an idea of what's going on. I took a sampling of actions from U.S. Attorney offices, which is the federal government under the Department of Justice, and they're looking into issues in healthcare. Now, U.S. Attorney Office involvement in healthcare at the physician level has significantly ramped up over the last 1 to 3 years. It is very, very scary to be involved in a U.S. Attorney investigation. Arrests are very frequent. Careers are ruined by even the indication of an accusation by a U.S. Attorney's Office. And sometimes when you're trying to do things the right way, but not really on the end scale of the spectrum for compliance, you could possibly be implicated in a U.S. Attorney action, and there could be severe, severe ramifications. So compliance for healthcare is a spectrum. For those of you who work with me on a regular basis, you know that I frequently say that. If I told you exactly how to operate your practices 100% to the T, adhering to every single rule that I have in my brain, you would not be able to, number one, make any money, or two, probably see any patients, because no one would sign any of your forms. On the flip side, the open end of not knowing any rules and doing whatever you want and operating without incorporating properly under a lay entity instead of a professional entity, and not bothering to understand what you have to do for HIPAA, and treating patients the way that you want to, and buying medications that you want to from wherever you want, not wondering if they're FDA approved. That is considered the far end of compliance. And there's somewhere in the middle of that spectrum, hopefully, where we can find that everyone is comfortable to practice, that will minimize potential exposure from the far end of the spectrum, but allow you to operate in a way that you are not having to shut down because you're on the front end of the spectrum of compliance. So we're going to talk about some mistakes that some people made and what they could have done to do things better, and I think this is the best way to learn by example. I know we're all familiar with our typical case studies, so we're going to do some legal case studies today. So this first one, which you've been staring at for a couple of minutes now, is HIPAA exposure. Now, this was fewer than 500 people affected. There was a stolen laptop for Hospice of Northern Idaho, and they were ordered to pay the government $50,000 for failure to conduct an accurate and thorough analysis of the risks to the confidentiality of electronic protected health information. And because Hospice of Northern Idaho did not adequately adopt or implement security measures sufficient to ensure the confidentiality of electronic protected health information. This is a very easy lesson for you to learn and for you to take away from today. Okay? There was a laptop that was stolen that had patient information. There were fewer than 500 patients impacted, which means that there could have been 1, 10, 5, 15, I don't know, or 400. I don't have that information available. The lesson here is that it's not that the laptop was stolen that created the exposure for this operation. It was the fact that there was no security policy on file with the practice, which is a written policy you're required to have under the security rule at your practice that discusses the measures in place protecting information that is electronic for patients. And that policy is very simple. It talks about having a security officer and having password protection, keeping track of your information, keeping track of your hardware. It includes all of the administrative, physical, and technical safeguards you have to have in place for your electronic PHI. And had a Hospice of Northern Idaho had this in place and then also conducted their analysis of the risks involved with the laptop being stolen, arguably they would not have had this exposure with HHS. And the risk assessment we're going to get to a little bit later when we talk about tips for your practice, it is very simple to do. HHS is not saying they had to go through a rigmarole of outside assistance with this. They possibly could have done it internally. I personally recommend, not just because I'm a lawyer, but because I'll explain why, it's important to have your attorney write up this risk assessment. And the reason is that this way you can show that you have brought in an independent person, not biased. It's not your office manager writing it up. It is a third party that is neutral, that can perform an assessment. Also, if it's your lawyer, they have malpractice insurance, and there's a reason for that. It's because if I'm in my independent judgment determining that you didn't have a risk, then I'm the one making that decision for you, and it's not coming from your office. So the lesson to be learned here is that, and this applies to every practice that uses electronic information. We're going to get to some other examples that are similar. A laptop could be used by your staff, probably is right now, maybe by you. It could be stolen, but is it password protected? Do we have these policies in place to make sure that if something happens, we do know what to do and what kind of assessment has to be done? So that's the purpose of this, and I hope everyone is taking away what we're going over here. Okay, here is another area, another example of exposure. This is from Affinity Healthcare, and you'll see the links that are on the bottom of these pages. These go to the OCR, the Office of Civil Rights website, and these are the links explaining, or the press release, rather, on this particular instance. And you can access these on your computer on your time, of course. So Affinity, a fairly large insurance company, they returned a number of copiers at the end of their lease to the manufacturer or wholesaler, whoever, and they did not delete the memory base on the copiers. And what was uncovered by Office for Civil Rights is that they disclosed up to almost $350,000. 350,000 individuals' information was on the copier when it was returned. And that is a massive, massive exposure. And they agreed to pay $1.2 million for failing to incorporate electronic protected health information in its analysis of risk and vulnerabilities as required by the security rule. So at the end of the year, you are required to report to the federal government your HIPAA violations for that year. And it's an online form. I'm happy to send it to you or happy to assist in your assessment. And Affinity failed to report this as an inappropriate disclosure. It came to light. It probably was reported by the copying company that they received this back. I'm assuming that's how they found out about it. And it resulted in significant exposure. So why bring this to light? I think it's fairly obvious, but know where and when you have a responsibility to protect, report, and address HIPAA exposure. Think outside the box. Understand in your practice, where do I have protected health information saved? Where do I have protected health information coming in? Who are the gatekeepers? And if you have this in mind and you want to have an open discussion about it, I'm of course available. But you want to make sure that you're thinking this way of, it's not just patient care anymore. There's so many different elements that you have to worry about being a practice owner and being involved in a practice. So you want to make sure that you're cognizant of the type of information that you have to be aware of and areas where you may be creating exposure in your practice. This is similar to the laptop case. This is VAPderm. This was a Massachusetts practice. This was big news. This practice got stuck paying a fine of $150,000 for failing to conduct an accurate and thorough analysis of the potential risks and vulnerabilities when they had this thumb drive stolen. Okay, and this was taken out of an employee's car, was the story here. And for those of you who read the newsletter regularly, we already did a newsletter blurb on this. This was really very interesting because it was very easy for it to happen. And it wasn't that the thumb drive, again with a laptop, it wasn't that it was stolen and that the practice lost the thumb drive. It was that the practice did not take proper steps to adopt policies and procedures in advance to protect against this kind of risk, number one, and number two, to address what should happen if this were to occur, if they were to lose protected health information. So what we got from OCR, and again, not to belabor the point with the newsletter having already gone out, but this is what they had said, Director Leon Rodriguez, an ounce of prevention is worth a pound of cure. And you want to make sure that you're adopting good risk management to protect against potential exposure. So this is push for written policies, and we'll talk about that a little bit later. This is also our website. We've done a good job branding, and we've got a bunch of different names that link, but we'll go over the different policies and procedures in a couple of minutes that you can have in place, and we can discuss with you which ones are necessary, which ones are required, which ones are recommended, necessary, and which ones are just kind of, if you want to have in place, you should. Okay, since we're covering patients and risk here, and I put HIPAA in this area, and I also put patient prescription use in this area, I wanted to highlight, we know this is a big problem, but Oxy is a big, big problem, and it's on the radar for the U.S. Attorney all over the country. I could have sourced just New York cases for all of these examples, by the way. They are out there. The U.S. Attorney for the state of New York is incredibly, incredibly active, and that's very concerning. But I purposely picked across the board to show that these things are going on everywhere. And not only that, again, all of these examples have been posted by the Office of Inspector General in the past 5 weeks. That's 5 weeks. So all of these things have come to light, and we're going to continue to have this type of rate where there's just so many people that are getting into trouble because the oversight is really incredible. That doesn't mean that we shouldn't be happy to practice and that we can't operate compliantly and that we can't sleep well at night. I definitely think that is the case, and we can talk about, we're going to continue to talk about ways that you can keep doing that. So This is a Washington doc that was busted for oxy for cash, and this was a hospital anesthesiologist, former hospital anesthesiologist practicing in private practice, pleaded guilty to distribution of oxy. What happened here was he licensed to practice since 2004, so it's presumably a young individual, operating medical clinics in Seattle and Washington, and he admitted that he was writing oxy for cash, and he obtained oxy that he distributed for cash, all without a legitimate medical need to do so. Now, I just want to make a really fine line here clear. For those of you on the line who have patients that have out-of-network benefits or maybe are coming to you for out-of-pocket, they technically could be, they're paying you cash in some instances. So the U.S. attorneys, this is an example that I'm using because of personal experience that I've had handling these cases for healthcare clients. We do all the civil work with, we usually work with a criminal attorney, and we help our clients through these U.S. attorney investigations. And what I've seen from the U.S. attorney is that there is a lot of PR work going on out of that office. And they will take a very innocent set of facts and sometimes a very innocent provider, and they will look at prescribing habits, and they will say or make massive allegations based off of trumped-up facts. So, for instance, say you have the majority of your patient population, or you believe 100% of your patient population is being prescribed to appropriately, and the oxy that you're prescribing and other pain meds you're prescribing are all appropriate, and some of the patients are paying cash for that. And the U.S. Attorney's Office or the DEA locally decides that they want to substitute their judgment for yours, and you're just prescribing too much, which, by the way, we do have this going on right now with a couple of clients that are being looked at, which is true, for this happening. And I don't particularly believe that they are doing any inappropriate prescribing, so this is what's concerning me. The U.S. Attorney's Office will call you and say, do you have any idea how many pills you prescribed last year? The number is astronomical. You prescribed 50,000 pills of oxy last year. Well, what does that mean? What is the prescription? What is the strength? How many patients did that go out to? Do I have a reason why I'm particularly prescribing that many pills? How much really is that? So they'll skew the facts in their favor. They have an agenda like anyone else, and their agenda is to make headlines. And right now, pain meds are a very, very hot topic. So if you are prescribing them, I would recommend to just look at your practices, make sure your medical documentation is really up to snuff, and that any time you do prescribe it is medically necessary, and make sure that you're using the prescription monitoring program, and you're going on the registry and checking for everyone who walks in, because that's what you're required to do right now in this state and also in New Jersey. Okay, so I think I've hammered that in. It's very difficult here with no feedback from the users. I like to really do things in person because it's easier to, I think, present, but I guess you're stuck covering and listening to whatever I want to cover today, so I'll just continue. This is another prescribing one, and then we're going to wrap up the prescribing issues. I just wanted to highlight this for you because I think a lot of doctors do this as a regular course. They'll leave prescriptions. This is a Kansas doctor who lost his license and more. He's paying a very hefty fine. Restitution of $100,000 and a fine of $25,000, and he's forfeiting his practice and his building and apparently his Ford pickup truck. And in addition to that, he's paying a money judgment of $400,000. This doctor had directed his staff or allowed his staff to give out prescriptions for controlled substances. So this were probably for patients that were coming in on a regular basis, or he knew maybe they did or did not have a true medical need. I'd like to presume that they did have a true medical need, and he left prescriptions with his staff. This is a regular problem. Another problem that I see frequently that can cause an inquiry into your practice, and a tip, is a lot of doctors are a little bit too lax with their prescription pads, and they may have staff members that have greedy, sticky fingers that want to possibly use some of those, or maybe patients who are left in a room where the prescription pads are in an open, unlocked drawer, or maybe even left out. You really need to crack down on these practices. Prescriptions should be written by hand by the practitioner as the patients are coming in. You really shouldn't be authorizing anyone who is not a licensed and authorized medical practitioner to write prescriptions. So if you have a PA or someone else in your office that's authorized to write, that's fine. I have no problem with them writing it. But just a tip, please, I recommend really cracking down on your prescriptions. That is a freebie from me to you, and I hope you listen. Okay. This was an interesting one. I felt terrible reading this when it came out because the U.S. Attorney, again, is so proud of themselves that they're making this bust of these 7 oncologists. And I'm assuming, or I want to presume, that they were doing what they thought was right for their patients and importing drugs that were necessary. And I haven't seen this before where the FDA has cracked down on this. You know, obviously everything has to be approved by the FDA, but this was interesting. So this was 7 oncologists that were busted for being paid nearly $2.6 million. They're paying $2.6 million after pleading guilty to importing cancer medications that had not been approved by the FDA. And this was the U.S. Attorney expanding their scope and delving into an FDA matter and making arrests for 7 oncologists. So this is just, I'm showing to you because I want you to be aware that, you know, there's oversight in every area of your practice, as you probably were already aware. But just to kind of bring it around, and tip for this one would be just be careful what you're doing. Obviously, the specific tip is don't utilize anything that's not approved by the FDA. But more general advice is just be advised, you know, the different areas of your practice. There is a lot of oversight, and we're just going to be generally careful. Okay, so here are some tips for your patients that we've kind of covered. We are going to skip the malpractice and licensure. For HIPAA, you really want to stay up to date with any changes. There were new laws issued last year. They came out in January. They were effective as of September. And you are required to have a new privacy policy. It is required. It has new language in it, so you want to make sure that you adopt that. Changes to your breach notification, we're going to go over that in a minute. And for your prescribing, we went over that. You need to make sure you're checking the prescription monitoring registry and that you're prescribing only when it's medically necessary. So HIPAA tips. This is for breach training. There's very easy ways to prevent, and we went over this when we talked about the stolen thumb drive and also the laptop, is you are now required to do not only internal preventative by having proper policies in place, training your staff, you are now also required to conduct risk assessments and also report on a regular basis to the government if you do have any HIPAA breaches. Every single practice has HIPAA breaches, every single practice, whether it's patient fault, whether it's human error on the staff side, every single practice. It can be as simple as handing the wrong discharge form to the wrong patient, sending out the wrong information in an envelope, mailing a Social Security number on top of an envelope. I've seen that done before. Innocent mistake from a staff member, but can be significant. It can be not you. It could be happen to you from a third party. You could have a billing company post incorrect information at a clearinghouse. I've seen that one done before. You could have a billing company send the wrong bills to the wrong patient, and that has to come back to you. So there's a lot of things you have to be careful with HIPAA, and if you have any questions, you really should just be calling because there is substantial exposure here. The government has the authority to fine, but that doesn't necessarily mean that you will be fined as long as you're adhering to your requirements, which are this. A breach is any disclosure of protected health information that is not authorized, okay? And authorized exposure of information is going to include for payment purposes, for treatment purposes, for healthcare operation purposes. Everything that's in your notice of privacy practices is going to be in there. You are authorized to disclose protected health information for. But for any other purpose, you are not allowed to share a patient's information unless the patient is going to give their own consent, of course. So let's talk about what's not included in a breach and what happens if there is a breach or what kind of assessment you have to be doing, okay? So this is very simple. This is straight out of our breach notification policy. Well, although it is modified to shorten a little bit for our purposes. So a breach excludes a disclosure to staff or other practice member or other practice or a business associate that has a proper relationship with you with a business associate agreement in place and a reason to use and access such information, and using information only in a minimally necessary scope. Okay, that's very important. And if such acquisition, access, or use was made in good faith and within the scope and authority and does not result in further use or disclosure. So there's an end of a chain here. We know that the information is not going to continue going down this path. It's not going to end up on YouTube. We can limit the exposure. A breach also excludes when disclosure is made, but you have a good faith belief the recipient won't and can't retain the information. I had this happen just last week. Okay, one of my practices handed the wrong discharge form to a patient. They called me very upset. They told me that the patient had made it down the hallway, had read the information, had turned back and given the discharge form back to them. I said, did you ask them if they took a picture of the information? They said, actually, they did. There was no information. There was no picture on the phone, and the patient came and returned it. And so the patient, we decided, did not have or would not likely retain the information. And there was nothing very sensitive on there. There were no STD results. There was no there was no real identifiers that we were concerned about. So we decided that this did not constitute a breach. We did do an internal assessment, which is the next step. A breach excludes when you can show through a risk assessment there is a low probability that the protected health information has been compromised based on the nature and extent of information disclosed, to whom the disclosure was made, whether the protected health information was actually acquired or viewed, and the extent to which the risk to the protected health information has been mitigated. So these factors I would do a full analysis on and write-up for your records to make sure that we have in writing that we have identified an area, we have mitigated exposure, we have done our risk assessment, and we have determined there's a low probability that the information has been compromised. Now, of course, there's certain situations where that's not going to fly. There will be actually more than a low probability, and we're going to have a duty to report to the patient and a duty to report to the government. You are not going to be fined for reporting. Okay, I want to repeat that. The fines are not because something happened. The fines are because something happened that you did not try to prevent. You were not adhering to required policies that have to be in place. Okay, and you did nothing to mitigate exposure. So if you are trying to actually operate compliantly, which, you know, if you're participating on this webinar and you're still listening, obviously you're taking steps to operate appropriately. And arguably, you know, if you take a few more steps and you implement a few things here or there, and, you know, you don't ignore mistakes when they happen, you will likely not have exposure. Okay, and that's the good news, and that's the point of this talk, is for me to relay these things to you and for you to understand that, you know, we can do things now to protect you later. I want to make it really clear that in staff training, it has to be said for any admin staff at the practice, they have to understand that if they do not report when things go wrong, if they try to cover up, that is grounds for termination. I think that's very, very important. I'm just going to stop for a second because I want to just show you, this is our website. I make it really simple for you with the information that I think you need, okay? An employee handbook is not required, but I do recommend it. I hear all the time, how do I make sure that my staff is complying appropriately with everything that they need to be doing? And the answer is that you need to have policies and procedures. So if you don't like how they're dressing, you don't like how they're speaking to people, you don't like how they're interacting at the office, you don't like that they're taking information home with them, all these things are in your employee handbook. If they're abusing time, check in or check out. This all has to be policy and procedure for your practice. This is an iStop policy. This is a prescription monitoring program that we recommend that you have in place if you are prescribing any controlled substances. This is the HIPAA stuff. Notice of privacy practices, this is absolutely required. You must have it, okay? Required by September 2013. This is an update from the one that you may have in place right now if you haven't updated it within the last year. It is a simple form. It's the one that the patients have to sign. This is the security policy we talked about before with the stolen laptop, okay, with the electronic health information. You're required to have in place a security policy that covers the technical, administrative safeguards, and physical. Sorry, that's missing here. You have to have that in place. The breach notification is the document that I just talked about and pulled from, explaining to your staff that, and well, really to your staff for training purposes, what constitutes a breach, what do we have to watch out for and be careful of with our patients. I'm happy to explain the rest of these to anyone who wants to ask, but the purpose of this webinar is not actually to just show you this. It's to educate you and just let you know what's going on. So I'm not going to spend much more time on the website. Okay, so these are the patient tips, training. So you want to adopt proper policies, which we just went over. That is our website. If you need help or you want to go over policies that you think you need, you can feel free to contact me. Payer exposure. I'm not going to spend a tremendous amount of time on this today because I know everyone has limited time, and each one of these topics could easily be an hour, and that's not what I want to do. I want to get through some basic overview, and then if you have any additional questions, you can feel free to contact me offline, or we can continue our conversations through the webinar, through other webinars, and through the listserv. So, payer exposure. I think all of us who work in practices are aware that just dealing with the payers to get paid can lead to exposure. Wanting money from them, which is what they're required to do as an insurance company, can create our own exposure. Areas of entry from an insurance company, we are all aware: pre-authorization, prepayment review, which is when they request charts before they pay us; post-payment audit, which is when they request charts after they pay us; quality assurance, which is now an appropriate way for them to ask or request for records; and site visits. Site visits are really important for me to highlight. Do not, under any circumstances, please, ever let anyone into your practice that you are not aware is coming in and you do not have your attorney present. I have physically been at practices where the government has shown up and they walk in like the Gestapo with cameras and recording devices, and you do not want to ever put yourself in that position. You need to make sure that as a gatekeeper for a practice, you keep the government out. You never know exactly what they're looking for. A lot of times they don't know necessarily what they're looking for. They know that you landed on a radar and that they want to come in and sniff around. And especially when you're dealing with Medicare, who is overseen by the Office the Office of Inspector General, and who's coming in with the U.S. Attorney and things like that, you want to make sure that you are not giving them reasons to look at you for other areas. So if you're involved in a Medicare audit, and I know some of our local contractors for Medicare have come in and tried to do on-site audits for a lot of practices, we want to make sure they take their scanners and they go home. We're happy to mail them records if we're required to give them records, and we have proper authorizations in place, but we do not want them in our practices. A lot of concerns from payers. Let's talk about their concerns. They have a pot of money that they don't want to distribute. So what are they using or raising as concerns on why they don't have to give you that money? Overutilization, lack of medical necessity, fraudulent billing. Fraudulent billing is the big one for the Office of Inspector General and for Medicare claims. There's False Claims Act, which can create substantial exposure for practices if you are knowingly or willingly submitting claims to the Medicare system that should not be submitted there. And we're going to talk about a couple of general examples of that. And if anyone has any specific questions, feel free to email me after, and we can talk about it. And I have some tips for you also on this, of course. Okay, let me see why this is not. Okay, so this is a the examples I'm going to give you here with the billing are going to be, hopefully you'll consider them fairly extreme. There are some that may resonate a little, and I'm hoping that's the case also, because I want to make sure that we're having productive time here and not just kind of going over the complete stupidity of some of your colleagues and what they could possibly engage in. So this is a Queens doctor, local guy, who's facing jail time and a fine. He submitted more than $15 million worth of sham bills to Medicare. Now this obviously goes on that far right side of the spectrum of compliance that we talked about. This is complete lack of an intentional, willful wrongdoing. What I understand of this situation, and the link is here, is below if you want to look it up, is that they provided a variety of spa services, such as massages and facials, as well as free meals and social activities to Medicare beneficiaries. So basically they're providing, it sounds like a social services daycare type situation almost, to induce those beneficiaries to allow their Medicare numbers to be billed for medical services that were never provided and were not medically necessary. So purportedly provided physical therapy and lesion removals. And in total, they submitted more than $15.1 million in false claims. Now, this is a massive, massive arrest and victory for the Office of Inspector General's office, identifying this amount of money and stopping this type of ring. Now, do I think that these people are evil? No. Do I think that they were perpetrating this massive fraud? Maybe. I'm not convinced by the fact pattern because, again, the way that the U.S. Attorney's Office and the Office of Inspector General frame a lot of these investigations obviously are in as a convincing manner as they can be for the public and also for any potential jury who's going to be hearing this type of thing. You know, they're framing their case, and they're doing that with the advertising as well. So I don't know. You know, if they obviously are here, they're pleading out, and they're going to jail, serve 12 months and 1 day in prison for their role. Obviously, I would assume that they have some level of culpability, but I'm not the attorney in this matter, and I'm not familiar with the physicians, so I don't know exactly what they did wrong. But you just want to make sure that you're careful on what you're submitting for, and patients you're billing for you actually see. Bill for them on their actual date of service. If patients ask you for a certain kind of accommodation, which is fairly frequent, of, you know, I need you to bill me for one thing here or this here or whatever, if they're a family member, please say no. Bill in accordance with the requirements. That's how you get yourself into trouble. I've seen that before where patients with out-of-network benefits as a favor might ask certain things. Don't get soft. Stick by your guns. If it doesn't smell right, it's probably going to get you in trouble. And the point is that one of the points that I want to make today, that I guess I haven't brought up yet, is that the reason why they're able to be a lot more oversight now is because of the technology that's advanced. And the government and the payers are very, very advanced in their ability to mine data from practices now. And it's easier for them to identify outliers and offenders of the system. Unfortunately, which we all know, practices are not as up to speed on the technology. It's taking us longer to get our medical records in place. It's taking us longer to figure out how to utilize the data we have in our hands. Well, that same data the payers all have, and so does the government through Medicare. They see what claims you're submitting. They see trends in patient care that you don't necessarily know how to track yet. And it's becoming a lot easier to land on a radar based on your billing submissions. So you really want to be very careful. And the way to be the most careful, I think, is to work with experts in this field that are able to help you. So there are, you know, coding consultants that can come in, that can look at your documentation, make sure that your billing is up to snuff and your coding is up to snuff. If you are switching to EMR, please, please, please do not copy and paste your notes. That is going to be the easiest way for them to see that you are not performing medically necessary care, you're not writing an individualized note, you're possibly overbilling. It's going to be very easy for them to identify through the electronic records, and that is one of the major areas of audit right now. And one of the tips I can have for you is to really spend time on your medical documentation. Okay, so next up, what did this guy do? Well, this doctor in St. Louis was busted for traveling while billing face-to-face visits. How did they figure this one out? Well, this actually came to light from a complaint, I believe. We'll see here. Yep, there was a complaint from an overdose. So Dr. Hassan was traveling internationally, and he was leaving his nurse to conduct a number of patient visits in his absence and provide his patients with assorted pre-signed prescriptions. See, we have pre-signed prescriptions here again, which is not so strange, I think, for practices. I think it's kind of a fairly accepted common practice for regular accommodation, and so the patients can come in. And I understand that, but you have to be very careful. It's not acceptable. It's not appropriate. During these same time frames, Dr. Hassan directed his office staff to bill Medicare for face-to-face office visits, presumably under his Medicare number. And during that time period, the DEA received a number of complaints about Dr. Hassan's prescribing practices, including a report from a fire department that a patient had overdosed and become unconscious in the parking lot of the medical office there. During a subsequent search of the office, they recovered a number of pre-signed prescriptions. Now, unless they had a search warrant, someone may have let them into the office and authorized the search. Okay, and that happens all the time. You open the door, you hear it's someone from the government, you're scared to say no, you don't think to call the attorney, you let them in. I've seen that 100 times. Similarly, you let them in and they talk to you and they are very nice and they say they're here to help you. They can lie and say whatever they want. They can lie, steal, and cheat to get the information that they want out of you, and you start talking and you figure, oh, what's the harm? They'll like it if they see that I'm cooperating. That's what they want to see, that I'm cooperating. Well, anyway, they got into this gentleman's office and they found the pre-signed prescriptions for several patients. They also found medical records for individuals with unusual controlled substance prescribing patterns. So that raised a lot of flags. Right now, he's potentially facing a penalty of 5 years in prison or fines up to $250,000. Obviously, Dr. Hassan's credibility is probably shot, and I don't think that he's definitely not going to be keeping his medical license after this. I shouldn't say definitely. There's always a chance, but I doubt it. So payer tips. Provide medically necessary care only to patients. Adopt a compliance plan, which has to do with billing policies. Encourage, authorize, and require staff training. Seek professional help. We talked about incorporating a billing and coding expert. Be amenable to changing how you document your practices. It has to do with working with coding and billing. If you want a referral for somebody, my firm does not offer that, but I work with many specialized and trained individuals that I'm happy to recommend and give you a couple of people to vet out. Require staff to adhere to new requirements as a condition of employment. Adopt new policies. If your staff isn't going to listen, they cannot stay. Okay. Third-party relationships, and I'm going to try to speed it up because I was hoping to get you guys out sooner, and I think we're going to be going to close to an hour most likely. Okay, third-party relationships exposure. This is anyone else who's coming into the practice other than the patients and the payers, essentially. And there's a lot of people. I know you get raps on the door regularly from consultants and other people. So inducements, this is a big concern, people paying you for stuff. Improper structure, whether the relationship itself is structured improperly, we don't have a proper contract in place with whoever's coming in, or whether or not they're not structured properly. A big concern that I have is that in my area of practice, which is really most of New York, but more so downstate. We do have plenty of clients upstate, but mainly more so downstate. I'm familiar with a lot of different practice consultants that are running around with different types of practice structures that they're offering to come in and help build. Maybe they're bringing in additional testing, or maybe they're offering to bring you in on their brand new big group practice, and they're promising you're going to have 30% uptick. The operation they may be proposing to you may be completely above board, but the problem is that where these individuals are possibly structured improperly, or they're doing things or cutting corners with other people they're working with, if they land on a radar, what happens is that there's a target to an investigation, and then there is ancillary people that are involved that get taken down with the target. So are you a subject to the investigation, or are you a target of the investigation? This is the criminal attorneys ask this all the time. And if you're the target, you're the main person, you're the one that's actually being targeted, hence the target. But if you are a subject, then that means you are someone who might be involved, may not be involved, might be someone who could be used as a witness, or possibly an informant, or maybe you're going down with the whole ring. So if you're getting involved with someone who could potentially show up on someone's radar as a target, you may be looked at and end up on a radar when maybe you're not doing anything wrong, but it's still going to bring scrutiny to the practice that's not necessary, that you really just don't want and would prefer to avoid. So other exposure is obviously failure to adhere to any rules, laws, or regulations. We kind of covered contract exposure. Damage to the practice for failure for third party to live up to their obligations. So a big one here is for the billing companies. Sorry, I know I tend to rag on you a little bit, but be really careful who's taking over your billing. They have a tremendous amount of power and control over your practice. And make sure that you're vetting them and that you understand that they're operating properly, and that you have a proper business associate agreement in place with them and a proper contract in place that deals with unwinding and treatment of claims and things like that. That's a whole other topic. Okay, let's talk about some third-party relationships here. A New Jersey pharmacist was busted for bribing for prescriptions. This was a pharmacist with a compounding pharmacy in New Jersey. He was arrested and charged by paying more than $50,000 to physicians to induce the doctor to make prescription referrals to the pharmacy. And obviously this is pretty bad. He was charged with violating the anti-kickback statute, which is federal, by using a middleman to provide repeated cash payments totaling at least tens of thousands of dollars to a New Jersey physician over the course of several months. Now, I don't know if the doctor asked for this money or if the pharmacist offered the money, but either way, they are both in trouble. And since the New Jersey physician isn't named here, it may be the New Jersey physician who maybe turned him in. I don't know. So, okay, here's another one in New Jersey. Sorry, New Jersey, not intentional. This is just, these are the ones that caught my eye. This one is very, very, very disconcerting. I think we may have already done a newsletter on it, but this is a New Jersey doctor busted for a sham lab consulting agreement. Now, obviously, many of us need to use a lab. We have specimens we need sent out, and we need to get that information back to properly treat our patients. So what do we do when this situation comes up? This is a doctor who was accused of accepting bribes in return for referring patient blood specimens and was paid $1,500 a month under what the government is calling a sham consulting agreement. As part of the purported agreement, the doctor was required to fill out a sheet titled Consultant Advisory Board Data Sheet that only took a few minutes to complete, and the doc admitted that he knew that the questions on the sheet had no real value and were designed to disguise the bribe payments. Now, we don't know what's going to happen to this doctor here, but the bribery charge carries a maximum potential penalty of 5 years in prison and a $250,000 fine. What's my problem with this example? Similar to what I talked about in the listserv newsletter, is a consulting agreement typically, if it's drafted properly, is not something that I would tell you you cannot enter into. Can you enter into a sham consulting agreement where money is not at fair market value and it's not drafted properly and it's really just to cover up money passing inappropriately? Obviously, the answer to that is no. But again, I'm not really sure. You know, they're saying the doctor admitted that he knew the questions on the sheet had no real value and were designed to disguise a bribe payment, but did the doctor fill out an actual sheet for every single patient? How many patients did he fill the form out for? How much time did he take or did a staff member take at his office to fill out the patient records? What kind of pressure was this guy under to admit that he was involved in an inappropriate bribery scheme? $1,500 a month is not a lot of money for administrative time for a physician. Did this doctor know that he was getting into an arrangement that was inappropriate? And the answer to that, I would say, is most likely no. I think that the way that the press release was drafted here, obviously, is to justify the charges and the case. Why would the doctor agree to this if it was not an inappropriate relationship? Again, I'm not his attorney. I don't know if I had this set of facts, and I don't know everything, but the bare minimum that I do know, I'm not sure that I would have gone down this road. A lot of times what people do is if they're a target or a subject in an investigation in the U.S. Attorney's Office, they're under a tremendous amount of stress. You know, their practice may be taken away from them. Their reputation may be ruined. The U.S. attorneys don't always play fair. They have a tremendous amount of power and authority, and it is very, 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 very scary. So sometimes you cut a deal just to get out from under their purview, and I understand that. That being said, I'm not sure under this set of facts that this was necessarily the right move for the doctor. So you always have to be careful who you're working with as well, and you want to make sure that the attorneys involved have your best interest at heart and that you know all of your options. So that's very important to say. Hopefully no one will have to call me for any issues like this, but if you do, that's my perspective and my approach on a U.S. attorney investigation. This is very, very scary. Before you enter any type of third-party arrangement, you should make sure that it is thoroughly vetted. A very key element here is the amount of money that was paid, the $1,500 a month, is whether or not it was fair market value. That's the main issue here. Was the $1,500 a month paid for the service, which is filling out the Consultant Advisory Board data sheet? Was it fair market value for what he was giving back to the lab? And if you can argue or answer that question with a yes, then this was not an appropriate charge, and the doctor shouldn't have been brought up on anything here. So that's kind of the analysis. And before you get into an arrangement, you want to make sure that's vetted. This was a cash for scans deal. This is a gastroenterologist who agreed to take cash payments on a per-patient basis from MRI facilities. Now, why am I showing you this? I'm showing you this I'm juxtaposing it with the sham consulting agreement. This one I have a real problem with. I'm not really sure the doctor should have been taken down for this. This one is clearly flagrant abuse of the system. This is a doctor taking cash payments on a per-patient basis. First off, right here at the bat, you cannot be paid a kickback. This is a kickback. This is a cash payment per patient. This is a definition of a kickback from an MRI facility in exchange for MRIs and CAT scans over a period of 3 years. This doctor faces 5 years in prison, $250,000 fine. This one is very different than this one, okay? This is egregious. The other one is questionable. This is tips for third-party relationships, and then we're almost wrapping up here, okay? In general, this is in general. Under the anti-kickback statute, federal anti-kickback statute has a number of safe harbors, and if you read them, they start to sound very, very familiar. Third-party relationships have to be in writing with specificity, okay? And I'm paraphrasing here. The agreement has to be in place for not less than 1 year term. Any fee has to be set in advance, consistent with fair market value, in arm's length transaction, meaning that if you were to go on the open market and pay for the similar services, they would have to be priced similarly, and not determined in a manner that takes into account the volume or value of any referrals or business otherwise generated between the parties, for which payment may be made in whole or in part by Medicare. Now, this used to be a big sticking point that, Jennifer, can I do this arrangement if I'm not putting any claims into Medicare? There's no federal payer. The answer used to be, I don't like it, I'm not comfortable with it, but technically under the laws it does say that if you're not involving a federal payer, then there's less exposure, and that would have been my answer. Now I can tell you that there are opinions by the Office of Inspector General's office that just because you're not accepting Medicare money for a particular situation doesn't mean that an arrangement could not be seen as an inducement or possibly impacting the federal healthcare system. So they have made that bridge, which I figured that they would, and you have to be really extra careful. And just because you aren't necessarily taking Medicare for that particular element of your practice, or it's not implicated, doesn't mean that you're not potentially going to have exposure. So everything needs to be reviewed with third-party relationships. And again, we talked about this with labs or any testing that you're doing, or anyone who wants to come into the practice and work with the patients in any other capacity than as your straight employee where they're possibly profiting off of the arrangement. That's what you want to be careful about. Okay. Employees, I'm not going to spend a terrible amount of time on because we have other webinars on our website, which I can pull up and show you where they are. So let me just see here. This is our website again. So on our healthcare website, we have a healthcare webinars page here that I'm hoping to update because I'm not pleased with it. But anyway, we have our webinars page here. So we have some HIPAA stuff. We also have some employment ones, protecting your practice when terminating an employee, and we'll be posting another employment webinar soon. But basic exposure from your employees, what did I do here, is a lot of areas, as you may know, okay? These are just some, but wrongfully terminating someone, you can fire an at-will employee for any reason at any time except for a discriminatory purpose, which would include sexual orientation, race, gender, or origin. There's a whole laundry list of things that you can't terminate them for, but as long as it's just because poor work performance or you just don't like them for a non-discriminatory reason, you could fire them. You want to make sure the documentation is done appropriately. That people don't like what's going on at the office and they have legitimate claims of hostile work environment. That's a big area of exposure. Classification claims, wage type claims. You're not paying me proper overtime. I came in. You're docking me for lunch inappropriately. You're not giving me the proper break of half an hour. Things like that. If you're making people work through lunch and not giving them proper break, you have significant exposure. I'm just telling you right now. So that's a tip. We cover discrimination. So adopt effective policies. We talked about an employee handbook, how it's important very basically. Training. You want to make sure training is there. Carry insurance. Most people don't know about this. This is employment practices liability insurance. It is a rider you can add to your general liability policy. It is typically very cheap, a couple of $100 a year even. It covers you for your legal expense and exposure if an employee comes after you for any of this stuff. I highly recommend that every practice have it. It is good money to spend. And if you have any questions on it, feel free to call me, but really the best person to call for the EPLI is your insurance broker. Okay, that is the end of this presentation. I hope that you enjoyed it. Questions are tough to take, but if you want to try to send them in, I'm happy to take them. I appreciate everyone participating today, and we will keep the information coming. So any questions, feel free to submit them to the webinar, to the newsletter, to me, and we'll be happy to do another presentation on other topics you find interesting. So feel free to let me know about that as well. Hope everyone has a safe commute home today, and thank you for joining us. Bye-bye.